State's response to defense third motion for Frank's hearing. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClellan and files its response to the Richard Allen's third Frank's notice and request for Frank's hearing based upon newly discovered evidence and request for findings of facts and conclusions of law upon any ruling on this request, referred to by the states as of defense's third motion for Frank's hearing. The state has reviewed the defense's motion and believes that the defense has misstated the facts in the motion and would respectfully ask the court to deny the motion without hearing. The defense's third motion for Frank's hearing alleges that Tony Liggett failed to include information about geofencing data in the probable cause affidavit for the search warrant for the residence of Richard Allen. The defense claims that if this information was included, the court would not have found probable cause to issue the search warrant. The defense seems to claim that the missing information is exculpatory as to Richard Allen. However, this information from the geofencing data is mischaracterized and interpreted by the defense. Even if included in the affidavit, the geofencing data would not negate, cancel, or eliminate the facts that supported probable cause for the search warrant regarding Richard Allen's residence. Further, Sheriff Tony Liggett did not intentionally lie or omit material information about evidence in an effort to mislead the judge in the search warrant affidavit. The state of Indiana filed charges against the defendant Richard Allen in this cause of action on October 28, 2022 for 2 counts of murder in violation of IC 35-42-1-1, parentheses 2, parentheses. The defendant has been in custody since his arrest. The court appointed the defendant representation on November 14, 2022. Since that time, several motions and responses have been filed by both the state and the defense. The defense filed its motion for a Frank's hearing on September 18, 2023. With memorandum, attachments, and several exhibits. That motion was followed the defendant's supplemental motion for Frank's hearing filed on October 2nd, 2023, and the defendant's additional Frank's notice filed on October 3rd, 2023. All motions were denied by this court without a hearing. The state has outlined the test used in Frank's in its prior 2 responses. In order to have a Frank's hearing, the defense's attack on probable cause must be based on deliberate falsehood or acts of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. The claim should print out specifically the portion of the warrant affidavit that is claimed to be false and should be accompanied by affidavits or sworn statements of reliable statements of witnesses. The defense must show that there is inaccurate or omitted information, and the probable cause is lacking if the omitted information is included. Franks versus Delaware, 438 U.S. 154 from 1978. Herein, the defense claims omissions, if included, would negate probable cause for the search warrant of Richard Allen's residence. Specifically, the defense claims that 1. Sheriff Tony Liggett concealed from Judge Diener that at least 3 phones were moving in and around the crime scene at the times when the murders would have been taking place, and that 2. The way the Lieutenant Jerry Holman memorialized his interview with Turko should cause alarm about what law enforcement chose to include or not to include in their reports. Number 1 issue, that Sheriff Tony Liggett failed to make the judge aware that geofencing data showed at least 3 phones in and around the crime scene at the time of the murders. In our case, the defense is alleging that the crime was committed by several individuals involved in Odinism. The defense has filed several motions with this theory contained in the motions. The defense continues to promote this theory to the public with no evidence to support the theory. The defense have come to the point where they are making false statements in their motions in a continued effort to support the theory. This is one of the occasions. The defense claims that the geofencing data shows 3 phones in the area of the crime scene when the murders occurred. The defense admittedly speculates that a map with 3 phone numbers is geofencing data that provides evidence of any of the 3 scenarios. Number one, that people are walking around and witness the murders, and none of them identify Richard Allen. Two, the persons walking around saw nothing and the murders did not happen on February 13th. Or three, the person walking around committed the murders. This, of course, promotes the defense's theory. Unfortunately, the defense do not understand how to read or interpret geofencing data, and once again have misinterpreted the information and have put misinformation in their motion. The defense was advised on March 4, 2023, that state witnesses specialized in geofencing data would be ISP First Sergeant Christopher Cecil, FBI Agent Kevin Haran, and or ISP Sergeant Pete Glogaza. However, the defense filed the third motion for Frank's hearing based on newly discovered evidence that was available during the first discovery disclosure in October 2023. And in the second discovery disclosure after counsel was reinstated, the state witness for geofencing data interpretations would testify that AT&T collects data from devices to include geolocation data. AT&T geolocation information is gathered from three sources: GPS first, known Wi-Fi triangulation location second, and cell sites or timing advance, which occurs when a signal is sent from the cell tower to the device and then back to the tower. GPS, if received, can be very good with an estimated accuracy range of 3 to 15 meters. Wi-Fi or triangulation estimated ranges vary between 15 and 100 meters, and cell sites or timing advance can range up to several thousand meters. The cell sites or timing advance is inaccurate because the geofencing data estimates where the phone is at based on how long it takes the signal to go from the tower to the cell phone and back again. This means that the device can be 3 to 15 meters from the pinpoint on the map up to several thousand meters, depending on how the information was collected from the device to the tower. When interpreting geolocation data, you can only consider that the device is somewhere in or near to the estimated range area that AT&T provides. Thus, if an AT&T geolocation in a geofence provided a Wi-Fi location with a center point on the Carroll County Courthouse, one could deduct that the location is in a range of 15 to 100 meters from around the center point. If that same scenario included a cell site or timing advance location, the actual location of the device could be in a range of 1,000 meters, plus from where the pinpoint is located. That could include an entire town of Delphi and beyond. When a person is in a rural area, oftentimes GPS and Wi-Fi location services are not available. Therefore, AT&T must resort to cell site location data. This is not an accurate way to pinpoint the location of a device. Further, geofencing does not track movement, so the fact that a pinpoint moves within a certain area is not indicative of a phone moving within that area. The map that the defense refers to is actually geofence data from AT&T. The points on the map represent GPS longitude-latitude points provided as part of a geofence from AT&T. Each longitude-latitude point has a range of uncertainty. The point is not where the phone is, it is simply the center point of the measurement. So even though the longitude-latitude point is near the crime scene, the actual phone could be more than 5,000 meters away from the point in any direction. The points have no data, no date, no time associated with them on the map, and so the map does not indicate what date and time the phone hit on that pinpoint. All this information was provided to the defense in spreadsheet form with discovery. They either chose to ignore that information or did not understand how to read the information. The defense's conclusion that 3 devices were found in or near the murder scene location at the time of the murders and what geofencing data means is an inaccurate evaluation or interpretation that is not supported by an analysis by someone with specialized training or knowledge in geofencing data. The defense's conclusion failed to consider the estimated range of those devices in the AT&T records or how the pinpoint data was collected. Further, although phones may have a pinpoint on a map that is in the area of the crime scene, the actual phone could be several thousand meters away. No geolocation expert assisting in the investigation concluded that the cell phones were in or around the crime scene when the murders occurred. The defense further fails to state that the owners of those phones were interviewed and cleared by investigators. This was certainly Sheriff Liggett's understanding when he signed the affidavit of probable cause. The defense should be required to provide reliable statements or sworn affidavits of persons properly qualified to interpret geofencing data to support their claim that the omitted information, if included in the probable cause affidavit, would cause the judge to deny the search warrant request for Richard Allen's residence. Issue 2. Does Lieutenant Holman's summary of his Professor Turko interview support the defense argument that law enforcement provided false information in the probable cause affidavit to obtain the search warrant for Richard Allen's residence? It's unclear as to the reason the defense chose to have at least half of the content of this Franks motion address events that occurred nearly a year after the submission of the search warrant and supporting probable cause affidavit. It obviously fails to meet the burden due to the fact that Turko interview could have no bearing on what the probable cause affidavit contains. However, if the defense is using this to support the assertion made in paragraph number 34 that law enforcement has attempted to conceal evidence or falsify information in other context in the case, it utterly fails for the reason that Lieutenant Holman did not conceal evidence or falsify information from Professor Jeffrey Turko. The defense alleges Lieutenant Jerry Holman interviewed Professor Jeffrey Turko and then lied about the contents of that interview and Professor Turko's statements. Lieutenant Holman interviewed Professor Turko in September 2023 at the request of the defense following his deposition. Lieutenant Holman's deposition included defense inquiry about investigative leads related to Odinism. Lieutenant Holman advised that a Purdue professor had been consulted by other investigators, but that he did not participate directly in the inquiry. The defense pressed Lieutenant Holman to re-interview the professor as to his findings and conclusions. Lieutenant Holman did a follow-up interview with Professor Turko at the defense's request. Professor Turko's initial report from 2017 clearly states in the introductory summary, it is not self-evident that these markings are runic inscriptions, nor is it immediately clear what they would mean if they were. However, the argument that these markings constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible. The following are conjectures based on the working assumption that these lines do in fact constitute a runic or runically inspired inscription. Clearly, Professor Turko was asked to assume the lined formations are runes. Lieutenant Holman did not attempt to deceive the reader or leave out key information from Professor Turko's report. However, Lieutenant Holman did another interview of Professor Turko to clarify his findings at the request of the defense. The defense outlines Lieutenant Holman's summary of that second interview in paragraph 18 of their motion. The defense then outlines what they believe Lieutenant Holman's summary should have stated in his report in paragraph 22 of their motion. The parties held a deposition of Professor Turko on March 21, 2024. At the deposition, Professor Turko stated under oath that paragraph 18 of the defense's motion more accurately reflects his opinion by comparison to that which was stated in paragraph 22. Paragraph 18 is from Lieutenant Holman's report, while paragraph 22 is what the defense believes Professor Turko's report means and includes the defense's application of Turko's statements to fact about Brad Holder and Patrick Westfall that were not provided to Professor Turko for consideration. Professor Turko stated that he was provided with only a diagram of lines in certain patterns on blank sheets of paper, which he then replicated, and color-coded for reference to his narrative report. Professor Turko went on to state that paragraph 22 does not accurately reflect his opinion at all. Professor Turko stated in his deposition that it is not clear that the sticks found on the girls represent Germanic rune script. The professor went on to debunk all the statements that the defense put in their motion, including that this was a ritualistic sacrificial killing. He stated that nowhere in the recorded history of Odinism has a sacrificial killing of children occurred, and if by some slight chance that this is that, it would be the only one in recorded history and goes against the definition of ritual, since a ritual is something that is done over and over again. The defense outright lied in their motion and misrepresented the true finding as Professor Turko, Lieutenant Holman, reported the truth, and his statement that Turko's findings were inclusive was correct. The defense's statements that Lieutenant Holman somehow was misleading in his report is entirely false. Finally, it is important to note that the interview of Professor Turko and Lieutenant Holman's narrative summary did not occur until nearly a year after the search warrant was executed. Again, the defense does not even claim that the Turko findings are an omission from the search warrant affidavit, but rather that it presumably is new evidence to support their claim that law enforcement as a whole is motivated to lie or misstate the truth as part of the conspiracy to protect Brad Holder or withhold evidence exculpatory to Richard Allen. The preliminary showing that a false statement was knowingly and intentionally given or given with reckless disregard for the truth, such that probable cause is lacking for the Richard Allen search warrant. If the commissions are included or inaccuracies are taken out, the Holman narrative of his Turko report are not relevant to the Richard Allen search warrant affidavit. The defense has routinely put theories and statements in their motions that are not supported by facts or any real evidence. This is yet another example of that. The fact that the defense has a theory of how the crime was committed does not warrant the state to put that into a search warrant. In conclusion, wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McClellan and files their response to the defendant's third motion for a Franks hearing and would ask the court to find that the defense has not met its burden to warrant a Franks hearing. The motion contains nothing more than their beliefs about what the geofencing data means without the necessary specialized knowledge to interpret the data and summarily conclude that it must be exculpatory and therefore a material, intentional, or reckless omission in the probable cause affidavit for the search warrant. Sheriff Tony Liggett did not intentionally or recklessly omit evidence or lie about evidence in the probable cause affidavit to support the search warrant in an effort to mislead the judge. The facts in the affidavit are true and accurate and are supported by evidence collected in the case. Sheriff Tony Liggett relied on that evidence when drafting the affidavit for the search warrant as the best reliable information known to him and related to Richard Allen at the time of the request. That there are no inaccuracies or omissions in the probable cause for the search warrant that are of material nature, and the defense argument that law enforcement dishonestly is pervasive and relates back to the affidavit in question is not supported by sworn affidavits or the reliable statements. Signed, Nicholas McClellan, prosecutor. Thanks for watching. I'm glad we could read this for you today. We'll see you next time on Deb's True Crime Notebook. And don't forget to like, subscribe, ring the bell for all notifications. Please leave a comment because we love to hear your opinion. And share this video with others.